Yes. We'd love to do it. We're all
we were just talking about you.
that are lovely. So yes, I'm still thinking that just trying if let's say we did
right.
so is there make that argument? But that's not why
They want
to trade because I was actually for kids. We got a ton of that's why I'm actually building
Get out at 1, but if you'd like to get out a little bit earlier than 1, let's take our seats and get ready for the next portion of our meeting.
Welcome back, everyone. It is 11:33 right now, and we can go ahead and turn to our next subcommittee, which is the Subcommittee on Oversight and Accountability. Martin and Mark Zayat are the co-chairs of the subcommittee, and I'm going to ask them to report on their activity. There you go.
All right, thank you, Nikki. This is Marty Michalowski from the CFPB. I'm going to go ahead and take part of our work and report out to you and then discuss it, and then Mark's going to take part of it, and we're going to split that up. We reported back in October of our meeting in September that we had with the subcommittee, and thank you to all the subcommittee members that gave their time and input and feedback on what we're doing going forward. But during that update and the meeting, we had set basically 4 guidelines or 4 things that we were going to start with and start looking at and working on. And I'm here to report on the progress of those items. We did meet in December 10th, and we were going to talk about these 4 items. The first item that we started to discuss was to identify current authorities for oversight and action. So this included really that 10-year review that I had discussed. So we were looking at audits, program reviews, inspector general reports, and so forth. So we went ahead and looked at that for 10 years. Nate Jones, one of the subcommittee members, took this piece of the project on and basically went through and worked to pull a variety of different reports. So he identified and collected over 50 government reports related to FOIA programs since the 1970s. Out of those 50 or so reports, we've actually already posted 24 of those on the subcommittee's website. So that's been posted this week, and you can review those. Those are focused on really GAO reports. This collection and the larger collection of the 53 does not include congressional or non-government entity reports. These are only government reports and not those entities. So just keep that in mind as we look through those. One of the things that I do want to solicit from the public and even other committee members is we have a strong desire to take input from the public and take input from others. So if you're aware of some reports that we don't have on our list or that we don't have posted, please guide us in that way so we can go ahead and pull those. If you have other things that you would like for us to consider that are along these lines of audits, inspection reports that you think are valuable, please send them to the committee so we can evaluate those and discuss those and consider those. Also with that, we plan on in the future to continue collecting and continue posting these reports as we uncover them or they're shared with us. But we also want to look at these and conduct a review and analysis to see what do they say. Are there perpetual problems year after year after year? Are there new things that were remediated and resolved that maybe we want to look at that practice and how was that successful and maybe apply that elsewhere? But if you want to help us, you can also look at these and see if you come to a different analysis or you identify some other trends or some other issues that you'd like for us to look at. So please look at these, consume them, share them, and then come back to us if you see something that you'd like for us to look at, or even come to a meeting and make a public comment. So we do ask you and we desire your input and your help in this area too. So just to recap, we have identified 53 reports. We have 24 GAO reports that are in that subset already posted that you can begin looking at and reviewing. And then if you have anything to share with us, please do so. That would be very helpful. One of the things that we're also looking at is next steps. I identified this as another item that we are looking at, but to determine areas for additional oversight. Once we begin this review, we want to look at this in a 2-step process. One is to look at the reports that are out there, what reviews have already taken place, what audits, what inspections, and then look for what has worked, what hasn't worked, again, what is perpetual, and then what can we suggest as next steps. So are there additional oversight roles, or are there additional guidance, things like that. So once we begin this analysis, we're going to go ahead and look at that next step. The other thing I want to talk about that we talked about in the subcommittee in December is assessing the FOIA public liaison role at different agencies and components. So what does that look at? What does that look like? What's successful? What needs to be improved? And that's something that we're looking at. So one of the things that I had worked on with other subcommittee members is to conduct a survey of this role. So some of the things that we're going to focus on in this survey is to assess, excuse me, assess what type of people are serving in this role. Are they FOIA professionals? Are they in a different role and this is a collateral duty? Are they trained? Do they have some education and experience with FOIA? Or are they working in a different area of responsibility and they just pick up the phone? So what are the people serving in these roles? What is their background? What is their training? It could come down to even, what is their grade and authority, or are they a supervisor in the supervisory position? Aren't they? Like what the statute calls for. So we are looking at doing a survey to all government FOIA public liaisons and assess those items to have a picture of what is the current status of that role and what does it look like. Some of the future plans once we conduct that survey is to basically look for opportunities for improvement. To kind of move this forward as well, we want to partner with the Department of Justice, OIP, to first have a discussion and then conduct the survey. So we're working with DOJ to set that up, to have that basically roundtable with agencies, get their feedback, even outside the survey. So the survey is a tool that we definitely want to use and we want to collect information, but we also want to set the tone for that survey, and we want to give the public liaisons an opportunity to share information with us, so it's a two-way street. We'd like to see what does this role look like in their agency or component, but also what concerns do they have. So it's a two-way opportunity for a discussion. So that's something that we're working with DOJ on, and we're going to be doing in the near future. And then we're also going to go into, I believe we're going to partner with the fee subcommittee to do one survey to agencies, so we're not sending multiple surveys out to agencies, but we're doing this in one avenue versus multiple. And again, if you, much like what Ginger had pointed on, if the subcommittee members have input for those questions or concerns that they want us to touch upon, please send that to our subcommittee so we can evaluate that and maybe even talk with you further, because we may have a certain approach, and then you may bring something to the table of an idea or a thought with that as well. So we do solicit your feedback as well. Those are the two items I want to talk about, and I'm going to ask Mark to cover the other two items as well.
Great. Thanks, Marty, and thanks to all the members of the subcommittee, and especially to Marty, who's done a good lion's share of keeping the subcommittee members up to date and pushing us forward. So as he said, we met on December 10th of last year. I'll deal with the other two items that we had identified as our sort of four main objectives. The third one dealt with attorney's fees. A little bit different from the issue of the fee waivers, although there is some relationship to it. And one of the things that we're looking at is to get a better sense of the cost to agencies that attorneys' fees, when we're successful in litigation, might be having on the process. So the last amendment to FOIA switched fees coming from an actual agency budget rather than the general treasury of the United States. It was intended to serve the purpose of incentivizing agencies to be more productive and to perhaps settle sooner rather than litigate, because if they lost the case, and especially if they're a smaller agency like Marty's agency, we could probably bankrupt them if we took a sizable, I mean, I know several of us have had, you know, six-figure attorney's fees settlements, and for some of the agencies that would be pretty significant. So we have no sense yet as to whether that objective or motive or thought has actually played out well. To some extent, the view might be that agencies have buckled down and tried to litigate more and harder in the hopes that they would prevail rather than lose earlier on or settle. So that would be part of the survey, actually, that we will participate in as well. And we're trying to compile more accurate information dealing with attorneys' fees, what fees were paid, in which cases, what for, etc. We're going to not reinvent the wheel, because there's actually an effort underway, and is it Syracuse, Anne? Right, track at Syracuse University that is just coincidentally looking at some of these same issues, and we are in touch with them so as to piggyback as much as possible and gather that information. That's a pretty simple one. The fourth one deals with, I'm sorry, the other thing about with attorney's fees and in litigation, we're going to be looking at just what kind of litigation there is that's going around throughout the federal government. There hasn't been a litigation review or analysis since the early 90s. And the question is, how best could we avoid litigation? And this sort of goes to the oversight and the fourth component as well. Are there ways, such as the mediation that OGIS provides, where we could avoid going into litigation and the cost that entails? Some of the data in the annual reports that the agencies issue deals more with man hours, and we're looking, as I just said, when we're going to look at what TRAC is doing, of more of the cost itself from the fees, the actual dollar out-of-pocket cost. But the review that was done back in the early 90s apparently looked at a set of cases that existed at the time pending litigation, and even some that had stopped. And in fact, once they reviewed the litigation, there were actually additional releases that were made, even though the agency had won. And I think somebody said, was it on Wallenberg? Yes. Is that right? Raoul Wallenberg, the Swedish diplomat. Swedish? Am I getting the country right? Swedish. Swedish, right? Swedish diplomat killed in World War II, or imprisoned in the Soviet Union, depending on which theory you want to go at. But that's a different story. And whether or not we can persuade or is necessary for an agency or entity to do some sort of survey of current litigation and see if there are cases that perhaps should never have been defended. If, for those of you who are familiar with the Attorney General memos that have come out in the last 20+ years, Reno, Ashcroft, and Holder each had one, and it talked about where if the Department of Justice did not, I'm paraphrasing, agree with the agency in question in a particular case, that they might not defend it. Well, to my knowledge, there's never been a case that the Department of Justice has not defended. And that could be because every one of those cases were defensible and should have been defended, or it could be that that statement just wasn't really taken to the heart that it was meant to be, and lawyers being lawyers, we just will litigate either on the prosecution or to the defense side, you know, regardless as how it comes before us. So is there a way for some sort of entity to examine cases as they come along and sort of almost be a neutral advocate internally to say, well, maybe we should second think this one or have some more discussions before we go forward? The fourth component of that in dealing with oversight was with the Office of Information and Policy. And on January 13th, we met with the director, our fellow committee member, Melanie Postay, and the chief of compliance, Bobby Talibi, am I saying it right, Bobby? Bobby's here in the audience, who gave us a wonderful amount of their time and a very productive discussion about the role that OIP plays. Now, with the creation of OGIS a number of years ago, we're looking at what different entities have an oversight role, what roles should they play, how can those roles be increased, if they should be increased in any particular way. And OIP within the Department of Justice, as I read from their website, responsible for encouraging agency compliance with FOIA, ensuring that the President's FOIA memorandum and the AG FOIA guidelines are, I think it says implemented, but it's cut off on my page, across the government. And they're looking at, as we were told, encouraging compliance, overseeing compliance, and Melanie and Bobby went through all these different areas that they do. And for example, OIP used to historically deal with issues if a requester or member of the public wanted to call in and had an issue with a particular agency, would go through OIP. But with the existence now of OGIS, they get very few at OIP because these type of cases tend to go through OGIS now, and OGIS has done an excellent job at dealing with those. So part of what we're sort of looking at is there any need at all to modify oversight authorities at different offices or agencies? We talked about OIP used to have a greater role in litigation than it does now. There was discussion, I know, and raised by some of us in the private sector, of some concerns with respect to, in particular, the FOIA litigation guide that the department oversees and issues, which is a fantastic resource, absolutely one of the best FOIA resources out there, written by the lawyers predominantly. And although Melanie has modified it over the years, and we'll take a look at this now as well, it very much reads, at least from the private perception, as more of a legal brief for the government's position. And what we're looking at, of course, is trying to get more of a neutral view as to what would the purpose of FOIA be. The purpose of FOIA is to have the release of information subject to one or more of the 9 exemptions being met. But the primary goal is to release. So as lawyers, the way we can write things, we can very easily write things. This is the argument we want to support, and here's the cases that support that proposition, or we can reword the same cases in a different way. But much of what happens with FOIA, as anyone who deals with FOIA knows, it is an attitude. It's the attitude that permeates through, particularly in the government sector and with the requesters, I'm sorry, those who process the request, and the attitude that they want to emulate. And if they have a positive attitude, it works fantastic, and if they have a negative attitude, there's going to be more withholdings. And that's a systemic problem that always has existed and will no doubt continue to exist, but we're looking at what other mechanisms can exist from that oversight standpoint to further encourage compliance, and as well, if we talk about what was going on with the fees. So a discussion of if there's going to be some sort of standardization of fee waivers, if that will still exist, because of the differences of the agencies. Well, okay, where's that going to come from? You know, who's going to create that? Should it stay as it is now? But even with OIP being part of the Justice Department, not every agency, quite frankly, has to listen to OIP. They can implement things certain in their own way. Now, it doesn't tend to be that way from what we've been told over the years, but every once in a while there can be an issue. So there is some limitation that exists, and is there a need for that limitation, to the extent it does exist, to be remedied in any particular way? So those will also be some of the survey questions that we compile to see if there is any further need for additional oversight. I think I've mentioned before at other past meetings, another type of example, as we'll look at some from whether it's a state or around the country, around the world, a sort of type of ombudsman. Should there be additional authority given to perhaps OGIS or another entity if that's the need? The example I've always cited, the country of Albania, which was not the mecca of freedom in the world, as the last communist country to fall. Within years of it becoming free in about 1992, by 1999 they had a new constitution largely based on ours. They had a Freedom of Information Act, and they had an ombudsman office that if you complained to it as a requester that an agency wasn't complying with your request, that office can tell that agency, not just mediate, but tell that agency that they needed to comply and order the release of information. Don't know if it's frankly worked or not in Albania. I just know that it exists. But we want to look at things like that to see if those type of examples would make sense here in the United States. They might not, don't know. But those are the types of issues that we're looking at with respect to this subcommittee. And I think that's it. Am I missing anything from the other members?
I would just add that enforcing compliance or encouraging compliance, you gave the good example of fees. I would also say the example of redactions or over redactions or maybe under redactions.
That was Nate Jones.
Nate Jones, yeah. Of course it was.
Comments? Anybody?
I have it's not specific to this, but I just want to flag it before I forget, a concern or an issue that I think as a committee we will have to deal with. A number of the subcommittees want to do surveys, and I know we thought that it makes sense to do one, but I know from surveys I've done when I've worked with people in the field, surveys that are long are a real problem. So I'm concerned, and I do think as a committee we're going to have to take a look at the best way to proceed.
I got to second you on that. This is Dolores Barber. And I have a concern, too, about the surveys, and I think we did discuss this in our subcommittee, the difference between taking a poll and doing a survey and making sure that we don't run afoul of any O&B requirements.
Right. I was, I may have used the wrong language. This is Ann again. We did address that, but I'm addressing a different issue as well, which is that whatever we call it, if it's a survey or a poll, if it is very long because it includes questions from all these subcommittees, I think there are real issues about getting responses, effective responses. I mean, there's a whole study, in other words, there's a whole science of doing surveys. So I just think we're going to have to be mindful of that and really figure out get our arms around, what's the universe of questions we have, and then how does it make sense to get the information? Is it one survey with everything, or is it multiple? So I just wanted to flag that.
And O&B actually has some guidance that they have posted about how to develop questions. And you're right, it can be a complex sort of thing, but there are certain steps that O&B might flag us on if we're, making this a widespread collection of information. And even what the survey tool itself might look like.
If you're talking about a survey only of federal employees in their capacity as federal employees, then at least that used to be outside Paperwork Reduction Act and O&B approval.
Right.
Nonetheless, I take the point that the survey has to be done such that we get a good response rate, and so you do want to look at length and understandability.
This is Ginger. I actually have some connections to some survey methodologists, so I could probably ask for a little bit of just pro bono informal help.
Sounds great. And I think this question came up before, and we have had some discussions with our Office of General Counsel that we can follow up on. Is that right, Krista? Okay, great. We'll follow up and let everybody know. Anyone else? Questions? Folks on the phone? All right.
Nikki, I have a follow-up question for the Proactive Disclosure Group. This is Dolores again.
Okay.
Thanks,
I'm going to take your ask back to my team and see if they might be able to identify larger data sets for you. But do you have a process for or a timeline about when you want people to get back to you?
We do not have a timeline established. If you're talking about having something to say within the next few weeks, that would certainly be timely.
Okay.
Thanks, Dolores.
Thank you all so much for your reports. And now we can turn to everyone else in the room. I want to thank all these folks in the room for attending this meeting. We're eager to hear from all of you as well, and we'll take your comments and questions for the next 20 minutes. Anyone? Please.
This one? Hello? My name is Michael Ravnitsky. I'm interested in the furtherance of open government, and I've been interested in that for some time. And in that capacity, I'm speaking on my own behalf, of course, and I've gotten to know some of the fine folks who administer FOIA in some of the federal agencies, as well as the motivated and altruistic, for the most part, people who are interested from the requester community in the same sort of issues. And I wanted to comment on one particular issue today and then make one comment about the fee issue that came up earlier. One of the quiet successes of FOIA that has not been commented upon much, and I haven't heard anybody talk about it, is the fact that some 70 to 80% of releases now to requesters are done electronically, either by email or on a disk or on a flash drive. And that's worked out very well, but it's led to one type of problem that I wanted to raise, which I've been hearing from a lot of people who I know. That is that there's problems with a lack of consistency and standards in scanning quality. Poor scans, poor resolutions, lack of OCRing. It's not 508 compliant, but it can't even be made 508 compliant because trying to scan something of poor initial quality makes it very hard. Locked or password protected files, password protected disks that are sent out and require special accommodations to try to even open and read, much less copy or use. Disinclination to release native files like an Excel spreadsheet or a flat data file or something like that. Instead, the preference is to print it out and provide some sort of scanned PDF of poor quality and making it very hard to use the actual underlying data. I know that people, there's a couple people here who are quite familiar with that. Unnecessarily huge files when they don't need to be, because people are unfamiliar with how to transmit electronic data. Archaic or obsolete software formats. I know people who have taken years to figure out how to crack open something they've gotten under a FOIA request, and that really shouldn't be necessary. And fragmented records or files broken up into lots of little pieces, which also is frustrating, I think, for some people. So those are things that could be easily accommodated and fixed if there were some sort of general suggested guidelines for agencies to have in releasing records. I think that the staff would benefit from having those kind of suggested guidelines. And there may be data quality or data format quality guidelines floating out there somewhere in the government, but I think that these don't need to be mandates. They can be suggestions, and they can be just really common sense sort of things, but things that people don't think about when they're processing a FOIA request. So the agencies are saving a lot of money and time and effort, and the requesters are happier because they're getting electronic records. But when you get to the point where the quality of these records is sometimes abysmal, and in order to make them usable by anybody, people have to go to great lengths, extraordinary measures to salvage the data. So the mention of this, something I wanted to say about fees was this, that I think that, and this hasn't been widely recognized yet because the DoD FOIA regulations are not yet issued in their final form, but what I saw of them in their initial form, and I'm sure that comments have been received to make them even better. Jim Hogan in particular is a very thoughtful gentleman. He's done a great job at formulating a set of regs that really accommodates a lot of the discussions that have been held in the FOIA requester and agency community over the last few years. And I think that those could be a model for other agencies in the future, especially in their dealings with FOIA fee categories and waivers and fee assessments and those sort of issues that come up over and over again. So I would encourage the committee to look at those draft regs and what finally is issued when they're issued, and perhaps see if that might form some sort of a model for future agency FOIA fee issues and regs. Certainly OMB might be encouraged to revisit their guidance, which is aging quickly and would benefit from a modern perspective. One of the big problems is to distinguish fee waivers from proper fee categorization, an ambiguity which I heard muddled a little bit here too. And I think that's very commonplace in the agencies. Some of them use it as shorthand, but some of them just don't get it. And I think that it's important to really maintain that separation between what's a fee waiver and what's a fee category, because those are essential things built into the law. I personally think the law is wonderful. I think the law works well when it's carried out, and the problem is when the rubber hits the road. The law isn't always carried out, and some of that is training and some of it is interpretation. There is an interstitial category that Mr. Zaid referenced, which is not really envisioned in the statute and the regs as they're written now, which is sort of people who don't fit into any of the categories but are not doing it for a commercial purpose and are trying to circulate information to the public. And I think there's a number of organizations which have sort of found a home somewhere, but that's not the best solution, and perhaps the agency regulatory, future agency rulemakings might be a good home for fixing that. You can't change the statute, but you can accommodate that by agency handling of FOIA requests in their regulations perhaps, and find a good solution there. Agencies probably have a lot of discretion to set the fee threshold where they want to. And I think that some agencies, which I am familiar with, have set it quite high, do not typically charge non-commercial requests. They don't charge non-commercial requesters, and they've done very well in that way. If they do find a voluminous, burdensome, or difficult request, then they can talk with the requester and have that conversation. And I think I can prove this point by saying that I believe agencies should not send out fee letters for more than $500 or $1,000. Nobody should be sending out a letter for $10,000. They should be picking up the phone and talking to the requester to mutually address the issue verbally or in a meeting. I think when you start sending out letters that arbitrarily assign large costs to a request, that's when you get into a position where people take firm positions and there's less opportunity for dialogue. So those are just my thoughts. Thank you.
Thank you. Any comments?
Yeah, actually, I largely agree with a lot of that. And one thing on the issue of FOIA regulations, so one of the other pieces of the National Action Plan was that the Department of Justice is supposed to craft a uniform FOIA regulation, or at very least model FOIA regulation for use across the government. A few of the groups here, CREW and EPIC and National Security Archive and OTG, have put together some model FOIA regulations, but I would encourage folks in the public to keep an eye on those uniform FOIA regulations as they're crafted and engage with the agencies on that.
That was Ginger McCall.
Oh, sorry.
Anyone else? Comments from our members?
My name is Jasmine Roberts. I'm new, actually, with the government, with data.gov under GSA, and one of my roles is marketing and communications. I know one of our goals with data.gov is, I think mostly everyone here would know that it's a harvesting tool and a catalog website for all these different data sets coming from the different agencies. One question I had was, I'm wondering, as we're gathering the different data sets from the various agencies, right now we're in this, we're in the stage of version 1.1 where we want those data sets in the JSON format. So I'm wondering, how do you see that role as we have a larger and larger amount of data sets available? How do you see that affecting the requests that are made directly to the agencies? Do you see that as being, do you see data.gov one day taking over where individuals can just come straight to that website and find what they need, or do you think that's going to be a long-term vision, or that's what I believe data.gov would be used for in the long run. So that would in turn then probably affect those fee structures and so forth. So I'm just wondering what you see, how you see the data.gov role, playing a role in that.
I'll go first. Nate Jones. I'm a strong believer that the more that agencies proactively post information, the fewer FOIA requests they'll get. And I think that there's a long way to go until we cross the, in my opinion, acceptable threshold of enough information posted to see fewer FOIA requests. But if data.gov is successful, we'll see it. And then I would also add that I think it would be terrific if agencies said, here is our data set of all of our FOIA releases in this year, and you guys posted it. I don't think I've seen that yet, and I think it would be a tremendous room for growth. So I guess the big point is use FOIA releases as a data set, because right now, as many of us know, and as I've said before, people spend hours processing a FOIA request, print it off, and it may go in someone's desk, never to see the light of day. And it's a waste of resources, and it's a good way to, a good avenue for proactive posting. Privacy and journalistic concerns notwithstanding, there's ways around that.
And also, when it comes to kind of touching base on what you were saying with the different formats, how realistic is it for the agencies to be able to convert some of those data sets into the JSON format so that it is accessible and easy to read and easy to use data for the public?
That might be a question for Gavini.
Would that be very time consuming? I'm sure it would be to a certain degree, but I'm wondering, is there a solution for that, for us to help in our goals and then you to help in your goals as well?
This is David Reed. I'm not qualified to address the technical question of what the cost is of converting to JSON. I do think we have to be aware of the issue that under FOIA, the requirement is for the government to disclose its records, and if it withholds any part of it, then it accounts for that. And therefore, any conversion of format from the native format the government is holding those records in into another format poses the question of whether the information has been changed. And so I think when we look at putting information into a format that's easy for external users to use, we have to, if we say that we're doing this as part of FOIA, then we have to look at whether we are following the FOIA requirements to present the government's actual records, you know, with any redactions clearly marked. So I don't know if that answers it or muddies the waters.
Well, thank you. I appreciate it.
Thank you. Any other comments? Nate?
I just have two quick comments. First, leading off what we've talked about earlier about the great comments on the OGIS website. There's many on there, but I want to just flag one great set that anyone interested in FOIA should read from the Society of Historians of Foreign Relations, which actually is a pretty broad survey of FOIA requesters. We've talked about doing a survey about FOIA processors. But they raise many of the issues that we brought up today, fees, proactive disclosure. They also mentioned B5, but anyone interested in FOIA and all of us should give it a good hard read. I also, secondly, my second point, wanted to thank Nikki for a great job, but I also wanted to state my concern as a member of this council that the FOIA Ombuds Office, the FOIA watchdog, still has not published a call for applications for the director of the place that looks out for FOIA requesters and FOIA processors. And I know things in the government can get muddled, but I want to state for the record that it's concerning, and I think many of my council members might agree, and I urge the administration or OMB or NARA or whoever to hopefully get this application up quickly and further strengthen OGIS. Thanks.
Thank you.
And thank you.
Thank you. As you all have heard, this committee has already been very active in its efforts to improve FOIA through the efforts of the 3 subcommittees that are underway. We look forward to hearing updates on the committee's work and also invite you to visit the website for more information about what we're up to and how you can participate. And one final thing to note is that all of you in this room will undergo the National Archives exit screening procedure to leave the building. For security purposes, all individuals' bags are checked to ensure that no archives holdings are removed from the building. And I want to thank everyone for coming, and we will see you all at our next meeting on April 21st, 2015. We stand adjourned. Thank you.